that abusing the mother in front of the children is abuse of the children as well. It does cause psychological harm. All right, we are back on the record.
And that's Exhibit 38, we're incorrect?
Yes.
Okay, move to admit 38, Your Honor.
38 is admitted.
Can we go to Exhibit 39?
Yes.
That's a police report from September 17th of 2020, correct?
Yes.
So in that one, what he did was, because he wasn't able to contact you directly, he started reaching out to your father, is that correct?
Yeah, my father and my friends.
Okay. And then your handwritten statement is attached there, and that is Bait stamp 569 and 569 and 570, correct?
Yes.
And it's a true, correct copy of the police report that you received?
Yes.
Your Honor, I move to admit Exhibit 40.
40 is admitted.
Sometime during this litigation, besides the criminal charges related to you, has picked up additional criminal charges. Is that correct?
Yes.
And the person that relates to is a gentleman named Jason Ellman. Is that accurate?
Yes.
Jason Ellman contacted our office and offered to provide us the documentation regarding the threats that was making to him. Is that accurate?
Yes.
Okay, can you go to Exhibit 40 in the book in front of you?
Yep.
This is a declaration of Jason Ellman for the records that he gave us, specifically texts from him to Facebook messages to his boss, texts to and other people, and Yelp reviews that put on him. Is that correct?
Yes.
Okay. He was arrested in the case against Jason for aggravated stalking. Is that correct?
Yes.
And then the documents show the call logs, the text messages, and they go into detail about how was going to essentially hurt Mr. Ellman. Is that correct?
Yes.
It specifically indicates that he's going to give him a Colombian bow tie or necktie. Is that correct?
Yes.
And based upon our understanding, that is where you slit somebody's throat and then pull their tongue through their throat. Is that your understanding?
Yes.
And that is all part of the criminal record for the pending case against Mr. Is that accurate?
Yes.
The court's indulgence, just a second, Your Honor.
Who is this man?
His name is Jason Ellman, E-L-L-E-M-A-N. You have no personal relationship to Mr. Ellman either, is that correct?
Correct.
In fact, when Mr. Ellman wanted to make the disclosure about what was going on, he actually contacted my office directly. He did not contact you, is that correct?
Yes.
But do we know who he is?
Yes. It's our understanding from the communication that Mr. Ellman is Mr. ex-girlfriend's ex-boyfriend, is that correct?
Yes.
And that's based upon these records and the videos from the hearing in the criminal hearings, is that correct?
Yes.
Okay. In these communications, represents that he has some ties to people who would complete this bow tie or this Colombian tie, is that correct?
Yes.
if we go specifically to bait stamp 958, bait stamp 959, this is where he says that, he has friends and references the bow tie, is that correct?
Yes.
He threatens that his friends are going to essentially beat Jason Ellman up, is that correct?
Yes.
And that's at 960. Bait stamp 960.
Yeah.
Okay.
Oh, this is on Facebook, okay.
So then we'll go into this. So in these, he's communicating with people through Facebook, and he references this litigation. Is this correct?
Which one are you on?
I'm on 962.
Yes.
Specifically goes into detail about his war on family court, about this judge, and about me particular. Is that correct?
Yes.
Okay. And this is all part of what communicated to and with Mr. Ellman and or his friends about related to the threats that were being made. Is that accurate?
Yes.
Your Honor, I move to admit Exhibit 40. It is verified by declaration. Mr. Ellman is prepared to testify if necessary, but I believe under Nevada rules, the declaration is sufficient to have it admitted.
Is it a public page?
Yes.
Then we'll admit it.
Did I say admit 39, Your Honor? I'm sorry.
I believe you did.
Yes.
Okay,
Yes.
so I move to admit 40, Your Honor.
40 is admitted.
After got unsupervised visitation with the children, did there come a time that he had to come to your house for those visits
Yes.
to do exchanges?
Yes.
Did the court explain to him prior to that what would happen if he acted inappropriate or at the time of the exchanges that he was doing with the children?
Yes.
Do you recall an incident where he approached the house late and then began throwing food and juice boxes at the house?
Yes.
And when did that happen approximately? Do you remember? Was it in 2019 or 2020?
2020.
Okay. Wait, was it 2021 or 2020 or 2021?
21, sorry.
21, okay. Your Honor, that is Exhibit 41.
And what was this date?
Do you remember the date of that?
I'm sorry. January.
Was it January of 2021?
Yeah.
Is that what you think it was?
Yeah, it was.
We're trying to pull up that video, Your Honor, real quick. I'm sorry.
We missed so many threats to other friends.
I know.
They don't know that? Okay.
Trying to access them, Your Honor, we're having just a bit of difficulty. Will we try to do that? Can I move on to the next one, Your Honor? real
Yes.
quick? Okay. Did there come a time during the litigation that you hired a private investigator?
Yes.
And who did you hire?
I forgot the name.
Was it Haldebecker?
Haldebecker, yes.
And why did you hire Haldebecker?
Because according to the kids, the visits were going unsupervised.
Okay.
And I wanted to have proof.
Okay. And so let's go to the Exhibit 42 in the book in front of you.
The next book.
Yes, book 2. Sorry, book 2 of 3. I'll wait, I'm sorry.
Okay.
Okay.
It is cold over there.
One second. You do. Oh, I'll get it.
Thank you.
Your Honor, may she put on her coat?
Yes.
Yes.
Are you there at Exhibit 42?
Yes.
Are these the photographs we received from Heldebecker?
Yes.
And these are photographs taken from November 14th of 2020, is that accurate?
Yes.
What was supposed to be happening during the supervised visitation at this time?
They were supposed to have Sarah or Tom McKinley with them, or my dad.
And his dad?
Yeah.
Okay, so on this November 20th visit, November 14th of 2020 visit, do you recall who was supposed to be doing it?
Sarah McKinley.
So indicated to you or through counsel that Sarah McKinley was going to do the visit.
Yes.
What in fact happened based upon the photographs that we obtained?
I dropped the kids off at Sarah McKinley's house. He came 10 minutes later, picked them up, and left without Sarah McKinley or Tom.
Okay. And so what was happening on this day is that paternal grandfather was there, but pursuant to the order, it was supposed to be both paternal grandfather and your father to verify that he wasn't doing anything inappropriate with the children. Is that accurate?
That's correct. And paternal grandfather knew that he was supposed to have my dad there, and paternal grandfather and grandmother did not follow orders.
Okay. And those are the 3 photographs that we obtained from November 14th of 2020. Is that correct?
Yes.
The person in the hat is, those are your 3 children, and that is paternal grandfather?
Yes.
And, Your Honor, we move to admit Exhibit 42.
42 is admitted.
Okay, I'm gonna go back to 41. It's the Ring doorbell of him throwing the items. Your Honor, can I approach her with the video on my screen?
Yeah.
I think you can probably see it from there, Your Honor.
Can you see it?
Can you
Yeah.
see it? Okay.
Yes.
Let me start it. Have you seen this video before?
Yes.
Is this the video where he's throwing the items?
Yes.
Okay. It happens quick. And this is from February 2nd, or February 1st of 2021. Is that accurate?
Yes.
So this shows he's getting out of the car and helping him out of the car. Is that correct?
Yes.
And is running towards the house.
Yes.
Who's the next one?
It's, oh no, it's
Brooke.
third one is.
So the kids come running to the house, and rather than deal with it, he just starts throwing things at the house. Is that correct?
The kids were still at the door, and he threw that. They weren't even fully in, and he threw it. That could have hurt one of the kids.
Okay. What was it that he specifically threw?
Full juice boxes and like McDonald's. Like,
Did you see if there was someone in the vehicle with him?
There doesn't appear to be anybody in the vehicle with him. This is not when he. This is not when he had supervised, right? This is when he had unsupervised.
This is unsupervised, yeah.
He had the 4 hours of unsupervised.
Mm-hmm.
Okay.
And the timestamp is really important in this. Do you agree with that statement?
Yes.
What time was he supposed to be returning the children? Do you remember?
It was 4-hour increments, 4 p.m.
Okay. And so this video was taken at, it says 16.
Oh, okay.
Oh.
Yeah, 16, sorry. 16, I think it said 6. I was like, 6 p.m.?
No, 16:33:54 is the time. So this is when he was 30 minutes late to exchange the kids. Is that correct, or to bring them back?
Correct, 33 minutes late.
Okay. I'm going to just finish the video real quick. It's just so that it's clear for the record.
As you can hear, the kids were still coming in the door, so when he threw the stuff, they were still at the door.
Okay.
So essentially, he threw the stuff at the kids.
So he threw the stuff at the kids when the kids did not respond to his calling.
Mm-hmm.
I move to admit 41. Or that's a exact copy of the Ring doorbell videos that we obtained from that date, correct?
Yes.
Okay, Your Honor, I move to admit 41.
41's admitted.
We also had, can you get 43 out? We also had, besides the video, or the photographs that Hal DeBecker took, you also had him take photographs, is that correct? I'm sorry. Sorry. That's okay. I strike that, Your Honor. Donald Wilburn just testified that was upset. He didn't want to go with. He was fearful of. Is that accurate?
Yes.
Is that what you experienced when you tried to do child exchanges?
Yes.
Did you take a video of Sarah McKinley trying to do exchanges with the children?
Yes.
Okay. And that is a true and correct copy of what would happen during as one of the exchanges, but similar to what would happen throughout when you tried to exchange with other people?
Yes.
Okay. Your Honor, I'd like to show her Exhibit 43. And Exhibit 43 is a true and correct copy of the video that you made, right, of Sarah?
Yes.
I'd move to admit Exhibit 43 and have it admitted.
43 is admitted.
Can you see the screen?
Mm-hmm.
You're taping this, and this is all wrong. And you are telling him you're going to...
So what was going on during that video?
Refused to go to the visit, like many visits he did, and Sarah McKinley went in the car and grabbed him out of the car, like physically grabbed him. And because, you know, he didn't want to go, he was screaming for mommy, and when he finally got a chance to get put down, he ran to me and held on to me as tight as he could. But he was really upset. He was screaming and crying to put him down, and she wouldn't.
And that was Sarah?
Yep.
We also have videos Hal DeBecker took from November 21st of 2021, correct?
Yes.
Okay. Your Honor, that is Exhibit 44. I'd like to play it for her and for authentication, and then I'll move to admit it if that's acceptable.
Give me 1 second, but yes, it is
Yes.
acceptable.
Okay.
Can I ask what the relationship Sarah is to the children?
Sarah McKinley used to be a family friend of ours, specifically of my dad's, and met her and her husband at my dad's house one day, and she kind of they became friends, and she said that if he ever needed anything, or anywhere to stay, to call her.
Okay.
And so he ended up staying with them, living with them.
Okay. All right. Thank you.
Yeah.
Go ahead.
Oh, sorry.
I just wanted to tighten
No,
my
that's okay.
thoughts.
Yeah.
This is a little shorter. It's about a minute and a half. Have you seen this video before? Do you know what it is?
Yes.
Okay. And what is it before we start?
It's a video of the kids going unsupervised with their father.
Okay. And this is from November 21st of 2020, correct?
Yes.
And this would be a time when he was having supervised visitation pursuant to the court orders?
Yes.
Okay. Your Honor, I move to admit 44.
44 is admitted.
Okay. I'm going to play it for the record. This shows alone with the children, is that correct?
Yes.
There's no other adult present.
Correct.
And he appears to be loading them in the car or taking them out of the car, is that correct?
Yeah, taking them out.
Okay, and can you tell where this is located?
His apartment parking garage.
Okay. And again, this is the 3 kids, there's no other adults present.
Yes.
Okay. And he's walking from the car. Again, no adults present, is that correct?
Yes.
And he picks up, which of the girls did he pick up? And again, they catch him walking from the car to the area, and there's no adults present, is that correct?
Yes.
And this is him going again into the building, no adults present, is that correct?
Correct.
On November 21st of 2020, do you recall who was supposed to be the supervisor?
Sarah McKinley.
Okay. Is it fair to say that after the domestic violence witnessed, it was difficult to get him to separate for you to have any visits with?
Yes.
Okay. And did you record periodically the attempts to get to go to the visits to show that you were trying to get him to go?
Yes.
Okay. Your Honor, and one of those was taken, is our exhibit 45, is that correct?
Yes.
Your Honor, I'd like to show her 45 for authentication purposes.
Yes, please.
This one's just a little longer, Your Honor, and I apologize. It's about 6 minutes. Oh, it's about 7 minutes, sorry. Can you tell me what that is, what's the start of that video? Where are you at?
Oh, this is my house. This was when there was supervised visits and Tom McKinley came to pick up the kids. And the reason why it's at this angle is because Lee and Sarah McKinley kept saying that I was intentionally putting it in front of his face and telling him to act up on purpose. So I put this there hidden so you could see that I didn't tell my son or show my son he was being recorded and he didn't fake it like they were saying.
So where was this recording device set?
It was on the, I have like a dresser there. This is my dining room table right here.
Okay.
And there's a dresser right there, and I put my phone, I can't remember what it was, but I held it right there so you couldn't see it. Nobody could see that it was there.
Okay. I'm gonna hit play. And
Okay.
you recall this video, making this video yourself?
Yeah.
Okay. And the two girls exit to go. And upstairs.
Yeah, he ran upstairs and he came back to check the front door now. He's at the door right there waiting. See, he's not going. I guess I should have opened the door wider. I just...
So this is out in the alcove or the front of the house, is that correct?
Yeah,
Outside?
I think I was helping put the girls in the car. I think it's like nothing happens for a couple minutes right here while I was putting the girls in the car.
With the court's indulgence, it's only 5 minutes. Can I continue to play?
Yes.
Okay.
Sorry, I should have cropped it, but I just wanted you guys to see like the whole process from before I opened the door.
Cropping it would have destroyed it.
Yeah,
Okay,
it's good that you
okay.
left it like this. Okay, so ran back into the house,
Mhm.
and you haven't entered yet. You can hear a door shutting. Who's that in the video?
I think that's our sitter.
Goes back into the screen. He goes back outside. He runs back in. Says he's gonna lock himself inside.
Mhm. She's trying to encourage him to go too. I don't know what I was doing taking so long outside. I don't remember.
So right now it's just the nanny or the babysitter.
Yeah. You heard earlier, he closed himself in the bathroom. Thank you for your patience. Sorry it's so long. Should we fast forward till I come on the screen and try to get him out?
It's only another minute and a half.
Okay.
Do you think at some point you come back in the house?
Yeah, I think Tom McKinley comes in and tries to get him out too.
Okay, so he's back in the screen.
He's curious. He's thinking the same thing. Why is mommy taking so long?
You don't want to come out? You're only going to go for a few hours, okay? You don't want to go any single hour? The girls are in the car already, and Daddy's waiting for you. And you know Daddy always spoils you with fun toys and mac and cheese and pizza. Well, then you could just tell him to make you something healthy. Say, you're going to go for some fun. Maybe you can convince him to make steaks with you. It'll be really fun. And Mommy will be here for you when you come back. I'll be waiting for you with open arms. Can you open the door, please?
So at this point he had locked himself in the bedroom, or bathroom.
Bathroom, yeah.
And you have multiple of these type of videos that we have where he was.
Yeah.
Okay. Your Honor, I move to admit exhibit 45.
45 is admitted.
Your Honor, I believe the court could take judicial notice that there are pending criminal charges that Mr. has been arrested on in case 19F 19371X, 20 PC 009075, 20 CR 009080, and 20 PC 014512, and 20 CR 039342. I'd ask the court to take judicial notice of that, Your Honor.
I'll take judicial notice of it.
And as the court indicated, he's still in custody status, and then there's another case, 20 CR 03934. In this matter, there was an indictment against for aggravated stalking against you, is that correct?
Yes.
And those are for the incidents that happened between January 1st of 20 and July 26th of 20, is that correct?
Yes.
As well as the destruction of property from June 22nd of 2020, is that correct?
Yes.
Can you turn to exhibit 53? Is that the indictment that was issued?
Yes.
Your Honor, it's a filed document. I'd ask the court to admit it as exhibit 53.
Which is exhibit?
53, it's the indictment in the criminal case specifically related to my client where he's been charged with felonies and gross misdemeanors.
Admitted.
The children have gone to medical appointments since the commencement of this action, and you've tried to share that information and obtain reimbursement from that correct?
Yes.
Okay, Exhibit 54, that's the note that you got about being lactose intolerant, is that correct?
Yes.
Move to admit 54.
54 is admitted.
55 is an outstanding medical bill related to the children, is that correct?
Yes.
Move to admit 55.
55 is admitted.
At some point during the litigation, he began communicating with Anna Trujillo, indicating that he was withdrawing consent for her to treat, is that correct?
Yes.
And 56 is a copy of the document that we received showing that he indicated that he withdrew consent to treat, is that correct?
Correct.
Move to admit 56, Your Honor.
56 is admitted.
You testified that there was a time when he was threatening family and friends, and I'm not saying that these are specifically related to this, but Exhibit 57 are some of the messages that you received from friends and family regarding him contacting them and making claims against you or saying that you're lying, calling you swear words, is that correct?
Yeah.
Your Honor, I move to admit 57.
57 is admitted.
Um, 58 is specifically to, what's your phone number?
702.
Whose number is 309? Okay, and you received specific messages from him wherein he's harassing you, calling you names, talking about your social media, making claims about you, essentially harassing in nature. Do you agree with that?
Yes.
Okay, and can you go to 58? Are some of those the messages that you received from him?
Yes.
Okay, Your Honor, I move to admit 58.
58 is admitted.
Who is Mario?
Mario was a guy I dated briefly after I had separated.
And engaged in conduct similar to what he's doing to Mr. Allman, where he began contacting Mario and making threats against him. Is that correct?
That's correct.
Okay, so go to Exhibit 59. Did you get these directly from Mario?
Yes.
And number is 309.
Yeah.
Okay. These are the text messages where he's talking about Mario, that essentially that he will pray for death, that he will destroy him, that you are a piece of shit, talks about other people that he's going out on, repeatedly calling you names, that he's going to camp out at Sweetwater Court. What's Sweetwater Court?
That's Mario's house.
Okay. That he will be dead. Do you recall that?
Yes.
And these are text messages that he was sending to you, correct?
Yes.
He says then on base stamp 431 that Mario is going to be fucking dead. Is that correct?
Yeah.
He specifically is indicating that he wants information about your romantic relationship with Mario and whether you guys have engaged in romantic relationships. Is that accurate?
Yes.
I move to admit 59, Your Honor.
59 is admitted. These text messages around September of what year?
2019.
2019. Okay, thank you.
So then we're going to go to the next set. These are again from, he's telling, his number is the 309.
Yeah.
He's constantly texting you saying, you know, I need you to respond, I want to get the divorce done. You're telling him, just calm down, please stop texting me at 3:40 in the morning. He's been contacting your dad, threatening your dad. Again, these text messages are different days and times according to this. He then starts sending you emojis about how harassing you about your weight, and this is where he says, I'm going to murder this piece of shit.
Yeah.
Don't expect good things if it's not going. Tell me what happened. If he's willing to die, something happened. He then goes on, because you don't answer him, he keeps going and going. Then the next day, he keeps going. He says he's downloading an app, that he's going to watch you. He's mad because you're not texting him back. He's telling you to answer him. You better answer him. He tells you Mario is fucking dead. Excuse my language. He then says, why don't we go to Paris next week? I found cheap flights. Then he asks you again, are you in a relationship with Mario? That he's going to kill Mario. Could be that he's going to kill him when he steps off the plane in Greece. Is that true?
Yes.
Okay. Your Honor, I move to admit 60.
60 is admitted.
Who is Gabriel?
A good friend of mine from college.
Okay. He then reached out on social media to Gabriel, is that correct?
Yes.
And he starts threatening Gabriel about how he's going to meet up with him and beat him up, is that correct?
Yes.
Okay. Can you go to 61? Are those the messages from to Gabriel?
Yes.
It says, I'm going to come to California and beat the fuck out of you. That's correct?
Yes.
Just kidding. Stay the blank out of our shit. Come talk to me as a man, you stupid little bitch, and I'm going to fuck you up. Is that all?
Yes.
Okay. And this is essentially what his behavior is like on a consistent basis since separation. Is that accurate?
This is what his behavior was always like.
Okay. I move to admit 61, Your Honor.
61 is admitted. When you said always like, what do you mean by that?
Since the beginning, he acted like this. I got pregnant really fast and I felt stuck, so I never left.
Okay.
But he constantly terrorized my friends. I lost a lot of friends because anytime we would go out, he would start to get really jealous and make stuff up. So I lost contact with everybody. He would harass and threaten people that were in my life, and yeah.
Okay.
So when you talk about harassing about friends, so these are Exhibit 62. Have you seen these before?
Yes.
And these are text messages again to you, right?
Yes.
And he tells you he's going to put Gabe in the ground. Is that Gabriel, the person that he was just messaging?
Yeah.
And he's calling him names and saying he's already buried. Is that correct?
Yeah.
Move to admit 62.
62 is admitted.
So 64, we're going to skip over 63. 64, do you agree that in this litigation has engaged in a period of harassment, not only of you, family, and friends, but your attorneys?
Yes.
Why do you believe that he did that?
To keep me scared.
Do you think that Mr. that believed that if he harassed your attorneys enough that they would withdraw or that you'd be without counsel?
Yep, that's exactly what he did with my friends. I lost a lot of friends. Specifically the one that he said he was going to burn down her house, and she was my major support. And so he would slowly harass people until they left me alone.
And that happened to Joe and Boris, correct?
Yes.
And not only did he threaten them, but he started threatening their family in the audio recordings that he left on their voicemails at their office, correct?
Yeah.
Okay. So 64 is messages that he would send to my office, correct?
Yes.
So his email is law.com.
Yes.
And you know Colleen O'Brien to be my paralegal, is that correct?
Yes.
An e-file at lvfamilylaw.com is the general inbox to my office, correct?
Yes.
In this email sent December 30th of 2020, which was almost a year ago, he addresses me as Mass Roberts, and he says that you're a prostitute and that you're trying to keep the kids from him. Do you see that?
Yes.
Do you need a minute? Want me to keep going?
Keep going.
Okay. And then if you go to the next date stamp, which is the next email, which is 389. He again refers to me as Mass Roberts, and he's contacting me about makeup visitation and you being a prostitute. Do you see that?
Yes.
Again, he calls you a prostitute one more time in this email. Then we've got another one at 392. Again, he's referring to me as Mass Pie. He says, could Mass Roberts please respond after her morning pie? Thank you. Do you see that?
Yes.
Okay. Then we've got the next one at 393. He addresses me as hey fat fuck. Do you see that?
Yes.
The next one is just the corresponding response to that. Do you see that?
Yes.
Is that how he communicated the majority of the time that he communicated with my office?
Yes.
Your Honor, I move to admit 64.
64 is admitted.
65 is a document that he sent after he'd been arrested. Do you agree with that?
Yes.
And this is an email that he electronically served on, or a letter he electronically served in my office February 4th of 2021. Do you agree?
Yes.
And it says, as Michael Jordan once said, I'm back. I'm sure your client has informed you of the events of January 23rd. Pursuant to communication with authorities, it is evident that you and your client conspired to file a false police report in June of 20 and further communicated with authorities to have me taken into custody in front of the children in an effort for me to miss family court on January 25th. Did we do anything to have him arrested on January 25th?
No.
Did we do anything to stop him from coming to court?
No.
Okay. You are truly the biggest piece of trash I've ever encountered. You and your husband must love being sued. This is all in relation to what he filed and after he'd been released, correct?
Correct.
Move to admit 65, Your Honor.
65 is admitted.
The voicemails that we received from Joe and Boris, we have those for the court, Your Honor. I will tell the court we had my staff, because we filed a motion regarding it, did a transcription of those. They're about 2 minutes in length. Would the court prefer the transcription or the actual voicemails?
We probably need to go ahead and put the voicemails in, and then the transcripts would be, it would show the transcripts are correct.
Yes. So this is Exhibit 67. We received these from your prior counsel, correct?
Yes.
And this is a true and correct copy of what was received?
Yes.
It's just an audio, Your Honor, so I'm just going to play it from here if the court's
That's
okay
fine.
with that. There's two of them.
Hey, Boris, fuck you! Fucking Boris, fuck you! Trying to move your fucking elephant. Fucking Boris, fuck you! They trying to go in there. You want to give them in Joe's name? That's what they're trying to do. They heard moving Boris, Joe's name. Fuck you, Boris. Coming for you, motherfucker. Coming for you and fucking Joe. They heard that shit? Fuck you, Boris! I'm fucking up for you, you fucking piece of shit! Fuck you!
So that's the first recording that we received from their office, correct?
Yes.
I move to admit 67, Your Honor.
Who is Boris?
Boris is Joe Riccio's business partner, do you know how to
Avramsky?
say it?
Boris Avramsky?
Okay, thank you.
He's an attorney at their office, Your Honor. And that's from July 2nd of 2021, correct?
Correct.
Okay, and then the second one is this one.
Are we admitting it, Judge?
Yes.
Hey, Boris! Fucking hilarious. Saw a video of contradicting Joe in open court when he's testifying in open court. Fucking hilarious. As I told the judge, he was lying, which Emily she was. And also, she goes, oh, Boris the Bronx is my attorney. I don't think he's a good attorney, but he's my friend's dad, so whatever. Fucking hilarious! Fuck you, bitch! Fuck you! Have Joe file more shit on your behalf? you, Boris. Fuck you.
So that's the second audio that they received September 16th of 2020.
Yes.
In the audio that we played from July 2nd and then this one, can you identify the voice making those recordings?
Yes.
Does he appear to be intoxicated during these?
Yeah, in the first one, yeah.
Okay. Your Honor, I move to admit 68.
68's admitted.
Then this is the third one he left for them. And this is the third one we received, right?
Yes.
And Boris, I got the message from the therapist that she hired you. So I'm filing a complaint against you for the ghostwriting of that complaint, which you knew was false because you have information you know is false in there. Also, yeah, Joe signing that it was served via USPS when it wasn't even served. Fuck y'all. Fuck you. Right? Fuck you. Fuck you. Fuck Joe. Fuck Vera. Fuck that little shit you call a daughter. Fuck all of you. You fucking piece of shit. Fuck all of you. Fuck. He sees you as a little piece of fucking shit. I've seen the text. I see everything. They see you as fucking shit. So have fun with it.
So that's the third one, and that's from the same date, correct? September 16th of 2020.
Yes.
Move to admit, Your Honor.
Admitted.
Who is Vera?
Vera is Boris's wife.
And the reference to the daughter is Boris's daughter, correct?
Correct.
Who's
My dad.
so that is maternal grandfather, correct?
Yes.
And how is it that you came to retain Boris and Joe as your attorneys?
Boris is a friend of my dad's.
And Boris and Joe are in the same practice, correct?
Yes.
Okay. And so there were times that Joe appeared on things and Boris appeared on things. Is that accurate?
No, Boris refused to take my case because he said that the court would say that he had a bias because he was a family friend. So
Okay.
he never worked on any of my cases or on any of my stuff.
Okay, so it was Joe who did the
It was
work on
always
the
Joe,
case.
yeah.
Okay. And we took, because we filed it, we did a transcription of those, correct? And you verified that those are accurate. Is that correct?
Yes.
Okay, so can you look at 66 for me?
I'm looking at 66. That's the
transcription?
Yeah.
And did you follow along the
I
transcription
followed
as we
along.
listened? And is it accurate?
Yes, it's accurate.
Move to admit 66, Your Honor.
66 is admitted. The court will note that I also followed along with it. There were a couple of statements, I believe it was on the first one, that was not made into the transcription, but it was pretty much just the same words as the last word on it.
We served discovery in this case, correct?
Correct.
We served interrogatories, requests for production, and requests for admissions. Is that correct?
Correct.
Okay. I know we're going to skip forward, but I want to start with the admission. So can you go to 72 for me?
Okay.
These were electronically served on June 10th of 2020. Is that correct?
Correct.
And not respond to that. Is that correct?
Correct.
So I want to go through these admissions. We asked you to admit that he had committed domestic violence against you as defined by NRS 33010. Is that correct?
Yes.
Request for admission 2, we asked him to admit that he had entered a plea in the battery case, which is 19F19371X. Is that correct?
Yes.
Do you remember what that battery case was?
It was the one where he vandalized my house
Okay.
in September.
And those are the bruises that were on your arms as a result of that. Is that correct?
No, the bruised one, I didn't press charges because I didn't know I had to press charges. I thought the state did that.
Okay.
So I just called the police and they were like, okay, noted. And I thought that they would process with it and they didn't. So
Okay.
the bruises were the August 1st.
Okay.
And nothing happened with that. It wasn't even brought up in court. The domestic violence counseling, that was from him vandalizing my house in September.
Well, let's go through this.
2019.
So the next one is request number 3. Admit in case 19F as in Frank 19371X, you are required to complete impulse control classes.
Yes.
Request for admission 4. Same case, he was required to commit domestic violence counseling. Required to complete domestic violence counseling. Is that correct?
Yes.
On or about August 1st, 2019, we asked him to admit that he struck you on the left side of your cheek. Is that true?
Yes.
On August 1st, 2019, we asked that he caused a welt on the left side of your arm.
Yes.
On request number 7, we attached photographs, and that was specifically Exhibit 1, and those were the photographs that we went over with the court. We asked him to admit that he caused those injuries to you on August 1st of 2019.
Yes.
We also asked him to admit that he sent the threat that he was going to place Gabe in the ground. That threat we just went over. Do you see that?
Yes.
Exhibit 9. We asked him to admit that he sent you a message saying he was going to murder someone known to you.
Yes.
Admit 10, that he stated that Mario would be drinking through a straw till he dies. That was part of the messages we went over to about Mario, correct?
Correct.
Admit number 11, that he was going to destroy the fucker's life, and that's in reference to Mario, correct?
Yes.
12, that he threatened to kill anyone in a relationship with you.
Yes.
13, that he stated he was going to kill you.
Yes.
14, we showed him as Exhibit 2 the photographs of the condition of the marital residence. We asked him to admit that he caused that damage.
Yes.
We asked him to admit that he broke 2 televisions, 2 chairs, appliances, furniture, vases, and a fishbowl at the house at... Those are the photographs that we went over with the court, is that correct?
Correct.
We asked that he admit that he caused physical damage to the home, specifically breaking a rear window, the front door, and the lighting fixtures at that residence, is that correct?
Yes.
We asked him to admit that he caused bruises to you again on September 16th of 2019.
Yes.
Caused redness on the left shoulder on that date, September 16th of 2019.
Yes.
Left elbow.
Yes.
Left side of your back.
Yes.
And that admitted the domestic violence that he committed upon you. Is that correct?
Yes.
Your Honor, we move to admit Exhibit 72.
And 72 is admitted. It is 5 till noon right now.
Okay.
It's probably a good time for us to break for lunch.
Okay.
So, all right, so we'll go off the record. Okay, good afternoon. We are back on the record. Ms. Roberts, please proceed.
Thank you.
Or continue.
Thank you. Emily, can you go to 73 for me?
Yes. I'm at 73.
Okay. So these are have you seen these before?
Yes.
These are the messages that actually sending directly to Mario, correct?
Yes.
These are where he's referring to you in a negative manner and addressing him specifically. Is that true?
Yes.
Move to admit 73, Your Honor.
Admitted.
74. This is a picture. Who is in the photograph? And these are messages that he sent to Sonia. Is that true?
Yes.
Who is Sonia?
Sonia's a good friend of mine.
Okay. Move to admit 74.
Admit. Sorry.
And go to 75. These are more messages from to Sonia. Just
Yes.
another version that keep going.
Yes.
Is that correct?
Correct.
Move to admit 75.
75 is admitted.
76, this is a receipt from the Children's Bone and Spine Center that you paid during litigation. Is that correct?
Yes.
There's 2 of them, one for 40 and one for 60.
Yes.
Move to admit, Your Honor.
Admit. Are these the only medical costs?
No, I'm going through them right now. I have a list at the end. So Exhibit 55 has the medical bills, and I forgot to move that other one down.
Which
So 55.
exhibit 55?
Yep. That was some receipts from the dentist for during litigation. In the Children's Heart Center.
Okay, let me go back. Go back.
That's okay.
All right, you want to go through these real quick?
Okay, yep. Go back to 55 really quick.
Okay. I'm here.
The first one is a $60 payment that you made to Randall Lomax. Who's the dentist?
Oh, it's an ear, nose, and throat doctor, actually.
Okay.
Yeah.
The next one is you paid on 10/2 of 20 for to Children's Heart Center.
Yes.
And it looks like you paid the $62.44. Is that correct?
Correct.
And then the next one you paid 10/14 of 20, $150. And that is to Pediatrics Medical Group. Is that correct?
Correct.
Who's that one for? Okay. Next one is a $25 payment to Healthcare Payment Systems. Who do you know who that was for? It's from Sunrise.
For
Okay. The next one is $35. Oh, sorry. This is the $60 to the dentist again. It's a different dental bill. Oh, hold on. Let me confirm it's a different dental bill. Yeah, this is from 9/14. This is for, and you paid this of $60, correct?
yeah.
Okay, the next one is a bill from Children's Pediatric Clinic. This is for, and it looks like you paid $35 out of copay.
Yes.
You paid that. Yes. Okay. Then we'll flip back to 76. You paid 40 and 60. Is that correct?
Correct.
Okay. Are you ready, Your Honor?
I'm totally. 492. Okay, go ahead.
And then on 77, you paid a prescription for the kids, one for 17 and one for 70. Those are both for the kids?
Yes.
Okay. And the next one, which is Bates stamp 574, you paid 8807. Oh, sorry. 8907.
Yeah.
And that was the CVS as well.
Yeah.
Move to admit 77, Your Honor.
77's admitted.
78 is a bill during litigation to Kid Fixers, and you paid $75.49. Is that correct?
Yes.
Who was that one for?
I think it was for all three of them. Let's see
Okay.
if it says specifically.
It doesn't. I just wondered.
No, I don't
75,
remember.
40.
And so 78, move to admit, Your Honor.
Admitted.
Do you need me to stop, Your Honor?
No, go ahead.
Oh, sorry. 78, was that admitted?
Yes, it was admitted.
Sorry. 79, this is for Summerlin Hospital.
Yep.
It says the account balance is $500, but the total charges were $47.57.
45.79.
Sorry, $45.79. Did you pay the $45.79 or just the $500?
I think 500.
Okay.
Yeah, 500.
Move to admit 79.
79's admitted.
Just so that we have context, what happened that resulted in being taken to Summerlin Hospital? Just briefly, you don't have to get into a lot of details.
Oh, he had an accident.
Okay, a little bit more specific than that.
Oh, he stuck a rubber band on his penis.
And so he required emergency treatment that day, correct?
Correct.
Okay.
Ouch.
Yeah, poor thing.
Exhibit 80. This is again for emergency room visit, and you paid $13.59. Is that correct?
359.
That's what I mean. Sorry. $3.59.
Mm-hmm.
Move to admit 80, Your Honor.
Admitted.
81. This one is for, I believe, and this is $50 that you paid. Is that correct?
Yes.
Okay. Move to admit 81.
81's admitted.
We're just going to keep going through the medical bills and we'll come back because I missed a couple in the records. Can you go to 84 for me?
Okay. In here.
84 is a $15 charge for Health Plan of Nevada for. Did you pay that one?
Yes.
Move to admit 84.
84 is admitted.
There's more on there.
Oh, there is? Okay, wait, sorry. Then we have Kid Fixers. You made charges. You paid on this one $50.49. Is that correct?
Correct.
Okay. The next one is Summerlin Hospital again. Total amount due $952.40. Did you pay that balance?
Yes.
And is this related to hospitalization?
Yes.
Okay. The next one is the CVS pharmacy bill for 2 prescriptions for the kids for $23.62. Did you pay that?
Yeah, so I don't give you all these receipts, but this is monthly.
Okay.
This is my son. Every single month I pay $23, but I always forget the receipts. He has respiratory issues, so he has allergy medicines that he takes. This is a monthly ordeal. And I don't have the receipts, but I mean, we can get it from the pharmacy or we can get it from the doctor or something.
Okay.
How many months have you been paying it without reimbursement?
Over 2 years.
Since your separation?
Since separation, yeah.
How many months was that? June, July, August, September, October, November, 18.
30?
24, 32.
32?
It was June, right? They separated in June?
Yeah.
The next one is UCLA Health Physician Services. That one's a $45 copay. Did you pay that?
Yes.
And the final one is again Quest Diagnostic. Let me just verify that this is not the same bill, that we didn't make a mistake.
I think this one is a mistake.
This is a duplicate?
Yeah, it takes
Oh
this
no,
one.
it's a different bill number. It can't be a duplicate.
But it doesn't say the right patient.
Oh, this is, so
Yeah.
1739 should not be counted, Your Honor. If we could we just remove that from this bait stamp?
Which one?
Bait stamp 739 is actually for, can we just remove that from the exhibits?
Yes.
Sorry,
What
that was a
exhibit was
mistake.
that again?
It's 84.
84.
It's bait stamp 739. Yes, ma'am, we can take it out.
Thank you, Your Honor. Okay, so then 85, again, this is that monthly prescription of $23.62, correct?
You want
Yeah.
We won't
84
add that in,
admitted?
I'm just, oh,
You want 84 admitted?
yes, please, Your Honor.
84 is admitted.
Okay.
And then, we're just gonna reference it, we're not admitting it.
Okay.
Same thing for 86, another showing the monthly prescription for, correct?
Correct.
Then we have 39, and 39 is Clinical Solutions, and this is a $25.50 payment. Did you pay that?
Yes.
You mean 87?
It looks like 81. Yes, 87, Your Honor, sorry.
2550?
And then the next one shows the actual payment of the $25.50, correct?
Yes.
Move to admit 87, Your Honor.
87 is admitted. Okay.
I think that's all the medical records, and we'll add them up, Your Honor, and just tell you the total before the end of the day today. if
The
that's-
2362 by 32 months is $755.84.
Okay, thank you, Your Honor. Go back to 82 for me. Sorry. I thought I moved them all. This is just a statement showing your Social Security earnings. So the most that you've earned was in 2011. Is that before you married?
Yes.
And that was 42,453. Is that correct?
Correct.
And what were you doing then?
I worked in like marketing for a merchant service company.
Okay. And that's the most you've earned in any given calendar year based on your IRS statement. Is that correct?
Correct.
And this is a true and correct copy of the IRS statement that you obtained. Is that accurate?
Correct.
Move to admit 82, Your Honor.
Admitted.
We talked about the harassing nature of communication to prior counsel into my office. The next one, 83, is the email he sent where he calls us a POS, which stands, we believe, for, well, the court building stands for. Is that correct?
Correct.
Okay, move to admit 83, Your Honor.
Admitted.
We've talked at length about Dr. Holland and her role in this case. Is that correct?
Correct.
So can you turn to 89? As part of discovery, there was a claim that my office had inappropriately communicated with Dr. Holland, so we produced all of the communication notifying her of the court order. Do you agree with that statement?
Yes.
Okay, and this is the totality of the communication back and forth with my staff, outlining the orders and what needed to happen. Do you agree with that?
Yes.
And that's from April till May of 2021, correct?
Correct.
Move to admit, Your Honor, Exhibit 89.
Admitted.
So Exhibit 91, the house that you bought this is the quitclaim deed or the grand bargain sale deed to you as a single unmarried woman. Do you see that?
Yes.
Move to admit 91, Your Honor.
91's admitted.
92, again, this is communication through Yelp to my office wherein he talks about me in a negative light, which he has done throughout the litigation. Is that accurate?
Yes.
Move to admit 92.
92's admitted.
94.
Yes.
Hold on just a second. This is the correspondence that Mr. sent to me where he refers to me by saying, "Can't wait to hear from you, Moon Pie." Is that accurate?
Yes.
Move to admit 94, Your Honor.
94's admitted.
On May 31st, 2019, sent an email to my general delivery email box at my office demanding information about a therapist that was not in place yet, I believe. Is that correct, to the best of your knowledge?
Yes.
And he indicates that he feels like we're playing dirty and helping abuse the children. Is that accurate?
Yes.
Move to admit 97, Your Honor.
97 is admitted.
98 is a copy of the retainer agreement you signed with my office. Is that accurate?
Yes.
Based on that retainer agreement, my hourly rate in this matter is $375 and my paralegals and support staff bill at $150. Is that accurate?
Yes.
Move to admit 98, Your Honor.
98 is admitted.
At the commencement of the trial, we talked about the fact that bar license has been suspended on a temporary basis regarding discipline. Is that accurate?
Yes.
We've pulled the information from the court's appellate website. Is that true?
Yes.
Move to admit Exhibit 100, Your Honor.
Exhibit 100's admitted.
101 is an email notification from Tyler Technologies showing that in a letter to our office entitled "Letter to Amanda C. Cow Roberts." Is that true?
Yes.
Sorry, Your Honor. Move to admit 101.
101's admitted.
102 is the homestead that you filed when you purchased the real property in this. Correct.
Correct.
Were you married on May 29th of 2013?
No.
Okay, move to admit 102.
Admitted.
Okay, 103 is the purchase agreement from February 21st, 2012 for the real property at 1913 Sundrio Drive. Is that correct?
Yes.
Move to admit 103, Your Honor.
Admitted. Nice climbing equity.
I know. Got lucky.
So turn to 105.
Okay.
These are mortgage statements. This is the statement right before you married, I believe. It's the statement for the period July 15th of 2014. Is that correct?
Yes.
And at that time, the mortgage was $997.74. Is that accurate?
Yes.
Okay. And based upon this, the principal payment is only $214.38, with $553.83 being interest and $226.53 being escrow. Is that accurate?
Yes.
Move to admit 105, Your Honor.
Admitted. 105? Yeah, 105.
Okay, so 106 is a current mortgage statement, or as of April 16th of 2021. That shows that the current payment is $1,134.83. Do you see that?
Yes.
Is that accurate?
Yes.
Okay. Of that, $294.19 is principal, $477.02 is interest, and the escrow fees are $363.62. Is that correct?
Yes.
And to the best of your knowledge, the escrow fees are the increased insurance and taxes. Is that correct?
Yes.
Move to admit 106, Your Honor.
106 is admitted.
In this matter, pursuant to NRCP 16.2, we reproduced your Bank of Nevada statements ending in 3541. Is that accurate?
Yes.
Do these appear to be the bank statements that we produced in this matter?
Yes.
Move to admit 107, Your Honor.
107 is admitted.
We also produced a account statement at 108, just showing the balance in the account. Is that correct? At 108?
Yes.
Move to admit 108, Your Honor.
108 is admitted.
We also produced the Bank of America, which ends the same statements that we just talked about, the Bank of Nevada statements, for an additional period. Do you agree with that?
Yes.
109, Your Honor, would ask to admit.
109 is admitted.
And then 110, we went all the way back to 2019 to produce records. And those are those records from the same account, or so a different account at Bank of Nevada, correct?
Yes.
Your Honor, move to admit 110.
110 is admitted. Let me ask you a question.
Yes, Your Honor.
Is there still $14,197.34 outstanding on the mortgage payment?
They added it to the end of the mortgage.
They're adding it, okay.
Yeah.
Well, it goes with how much,
Yeah.
money has been paid towards that.
Yeah. So yes, all 14,000 were added to the end.
Did you get during the, why did you end up owing $14,000 toward the mortgage, do you know?
Because I put it on forbearance during COVID because I wasn't receiving child support.
Okay. Can you switch to book number 3 now? Do you have that in front of you?
Give me a second, please.
Yes.
I need this to stay here. Thank you. I'm still calculating. I got it. Whoops. Get off there. And out. Go ahead.
Sorry.
That's okay, you're fine. I was just
No, that's
trying to keep my figures good here.
So then 111, can you turn there?
Yeah.
So these are the continuation of the statements from 8473, is that correct?
Yes.
Okay, move to admit 111.
111's admitted.
And then 112, Bank of America. This is a credit card, is that correct?
Yes.
And this ends in 5689, is that your credit card?
Yes.
Okay. And these are the statements from August of 2019 through November of 2020, is that correct?
Yes.
Move to admit 112, Your Honor.
112 is admitted.
Based upon this record at date stamp 167, as of essentially October 20th. Wait, hold on, maybe
Which number are we on?
same set of exhibits on off the
112?
statement. Can you go to date stamp 171? So through November 20th, you owed on this credit card $11,2062. Is that balance still owing?
Yeah.
And is the amount the same?
Give or take $100.
Okay. Then we have 113. Can you go there with me?
Yeah.
This is another account that you have. It's just a checking and savings account. This is Bank of America statements ending in 9478. These are August of 19 through January of 2020. Is that accurate?
Yes.
Move to admit 113.
113 is admitted.
You also have another Bank of America credit card ending in 0153. Those are at Exhibit 114. And those are the statements from August of 17 to November of 20. Do you see that?
Yes.
So based upon this, in November of 20 at date stamp 243, you owe $27,1258. Do you still owe that balance?
Give or take $100.
Okay. Move to admit 114, Your Honor.
114 is admitted.
You also have a Chase credit card. That one ends in 5682. We produced those records through December of 2020. Is that correct?
Yes.
Okay. And based upon date stamp 259 on that credit card, you owe $1,044.89. Is that accurate?
Yes.
And do you still owe that balance?
Yes.
1 second. Where is the account number on this, Chase?
It's right under account statement. If you see the blacked out part, the last four are there.
I don't see any last four at all.
5254.
No, there we go.
Oh.
5682.
Yeah, and it changed. It went from 5682 to 5254. Is that right? Did you change cards?
No, I have 2 Chase credit cards.
Oh, okay, then that's my fault, Your Honor. So for 5682,
You have that one on Exhibit 116. The other one. So one
oh
Chase
no, I have
card.
3 here, because I have 5254 too. Did you have 3 or did you change numbers?
Oh, maybe it changed numbers, but
I think that you changed numbers and this is that one, because it's the same.
Oh, sorry, I didn't know.
Yeah, it's the same. I think that we determined that because it's the same spending limit of 1,300.
Oh, okay.
Okay.
Yeah.
So move to admit 115, Your Honor.
It's admitted.
And then 116 is the second Chase credit card.
Yes.
And we produced those from October of 19 through November of 20. Is that correct?
Yes.
And this started 5919. Let's see. Let's verify. And then it changed to 7774, but they have the same spending limit. So I believe it's the same card. Does that sound accurate?
Yes.
Okay. And so as of payment date December 21st of 20, you owed $5,404.79 on that credit card at stamp 319. Does that remain accurate?
It's a little higher now.
Okay, what is it right now?
I think 6,200.
Okay.
6200.
Yeah.
Move to admit 116, Your Honor.
Admitted.
I realized, Your Honor, when I did the court, or when I did the exhibits, we forgot to put in Mr. book, so I brought a copy for the court and a copy for the court clerk.
Thank you. I have 117. And 118.
Oh, you do? Maybe it's my books that are missing.
119, 120,
You do? Okay.
121. I have all the way up to 123.
Okay. They're my books then. I apologize. Sorry. So we'll make them chip through this exercise.
That way you don't notice the cold.
Should make with that.
Right, I'm freezing.
Okay, so can you turn to 117?
Yeah, I'm here.
So provided limited statements in this matter. Do you agree?
Yes.
So he provided August of 19 through December of 20 after being compelled for the joint account ending in 9522. Do you agree with that?
Yes.
And these are, we know these are because they're bait stamped different. They're bait stamped DFNT. Do you see that at the bottom right hand corner?
Yeah.
Your Honor, as an officer of the court, I'm going to represent to the court. These are what Mr. gave to me, and I would move to admit them.
Admitted.
What numbers?
117.
117.
Thank you.
118, then, these are the statements that gave us himself, and again, they're denoted by date stamp DFNT, and they are for the account ending in 3573. It's his personal account. And those are only May of 20 through February of 2022, or 2021, correct?
Correct.
Okay. Your Honor, I would move to admit 118.
Admitted.
118 is another account just in his name ending in 2348. Again, bait stamp DFNT, which denotes that they were received from. Those are March of 20 through December of 20. Is that accurate?
Yes.
I would move to admit that, Your Honor.
Admitted.
120 are the limited records that he provided pursuant to the Discovery Commissioner's order, Your Honor. They are the law firm records, but he did produce them, so I put them in the books. They are not the IOLTA account statements. They are the general account statements for the firm. Because we never received the IOLTA statements.
Okay.
So these are this is the first time you're looking at these. They are the records for the account ending for law PC ending in 7891. You see that?
Yeah.
And these were produced by based upon the production date stamp of DFNT. Do you see that?
Yeah.
Move to admit 120, Your Honor.
You mean 121? Where are we at 121?
We're on 120 still, I thought.
Oh. Admitted.
He gave some federal loan statements that were dispersed in 2013. When did you marry?
2014.
Okay, and so these were dispersed and the loans were received before you got married. Is that accurate?
Yes.
And during the marriage, he was paying these loans from the community funds. Is that accurate?
Yes.
Again, these were produced by as evidenced by date stamp DFNT. Do you agree with that?
Yes.
Move to admit 121, Your Honor.
Admitted.
During litigation, he received the PPP loan in the amount of $23,000 from Cabbage. And again, these were produced by BAT based upon DFNT being the beginning of the bait stamp. Is that accurate?
Yes.
I move to admit 122, Your Honor.
122 is admitted.
And then in bait stamp 123, if you can move there, he has a promissory note with Lending Club for $21,000, $21,275. Do you agree with that?
Yes.
To the best of your knowledge, did you ever co-sign on a Lending Club loan?
Never.
And do you know anything about the Lending Club loan?
No.
And all this has is, it doesn't even have his name on it. Is that accurate?
Yes.
Move to admit 123.
Admitted.
Based upon the numbers that we provided for medical, I would represent to the court that the total amount that she paid was $3,435.23. So Mr. share under, if he was paying half, would be $1,717.61. And that's for those medical bills we went over in exhibits 55 76, 77, 78, 79, 80, 81, and 84.
I came up with the, what are you doing? I came up with a different amount. I came up with $913.87.
It has to be more than that because one of the bills alone was $952.29.
Well, for half, for his half.
Okay, can I add them? Can I add them real quick?
Yeah, add them up real quick, please.
No, I'm gonna do it on the computer.
And I'm re-adding also. Oh boy, my figures are way up there now. I've messed something up.
Yes.
What number do you have?
I get $3,435.23. And
Yeah.
so his half would be $1,717.61.
Give me your numbers again.
$3,453.23.
I got
So- What?
I've got even cents, but go ahead.
You want me to add them again?
No, you're fine.
And so his half is $1,717.61.
Yeah.
What about health insurance?
That comes up slightly lower than what my third addition was, so we'll go with that one.
Are you currently providing health insurance for the children?
Yes.
And who's the provider? Who do you provide it through your employer, or how do you provide it?
Yes.
Okay. And does your dad pay it, or are you paying it?
I pay it.
And what's the amount for the children only?
I thought I sent it to you. Can I look through my email?
May she look at her emails, Your Honor?
Yes.
Briefly?
I think it's my email.
Let me see if we have it on.
I have no service.
What?
My emails aren't working.
Log into the court. Log into Blue.
If it comes up Clark Guest.
Yeah, Clark, like to Blue.
With the Wi-Fi.
Wi-Fi password.
Okay. Clark Guest.
Yes,
Yeah.
just click on that, it's free.
Okay.
Who's the insurance? What company has the insurance on mine?
Health Plan in Nevada. I'm texting my HR person really fast to see if she can get in detailed.
When did you start covering the kids?
when my son was born.
So you've covered him throughout.
I've covered him throughout always.
Has ever had health insurance for the children?
Never.
Maybe it's on your FDF. Let me look at it.
Yeah.
So on your first FDF you filed with Mr. Riccio, you indicated that it's $95 a month total with 50 to you and 45 to the children. Does that sound accurate?
Wait, say that again?
50 of it is attributed to you and 45 is attributed to the children?
No, my health insurance is like $1,200 a month
Okay.
for the three of us. I'm trying to find a detailed list. I'm sorry.
That's okay. Let me look.
Okay, here it is. It is $253.98 per. Oh wait, no. Which one did you choose? Sorry, $267.66.
200.
67.66 per child. They have full health insurance and full dental.
And what are you looking at to determine that number?
They sent a rate comparison when we renewed our plan. It shows our current plan and our renewal.
Is it an email?
It's in an email, yeah.
Your Honor, could we send that to the court clerk and then have that lodged as our Exhibit 125?
Yes.
Because she used it to refresh her recollection.
Yes.
Madam Clerk, do you want to write down? Can you
Yeah, I'll write it down.
whatever you say?
So this has like confidential information of my other the other employees. So I
Oh.
think maybe that's why I didn't submit it.
Yeah, but that would need to be redacted
Redacted.
out.
So can I redact it and file it under seal, or can I file it under seal after I've redacted it as our 126?
Yes, ma'am.
Okay,
I'll send you the whole thing.
okay. Okay, and so it's $267.66 per child, so you're paying $802 for all three children.
Yes.
Okay.
So I want to get the numbers right. So from 2015
Uh-huh.
up until November of this year, it was $253.98, and
Oh, 253.
$253.98, and then starting December of this year, it was $267.66 per child.
And when you say this year, you're talking about 2020.
2021, yeah.
That's what I mean, thank you. Okay.
So now it's $267.66, but it's always been $253.98 per child.
253.98.
Times 3.
So it was, until this month, it was $761.94 a month.
Mhm.
And so your allegation is that not paid it from June of 2019 to December of 2021, which is 32 months.
Correct.
And so you're asking for reimbursement for the 32 months?
Yes.
So the total health insurance you've paid in those 32 months is $24,382.08,
Correct.
and you're asking that pay $12,191.04.
Correct.
And going forward, what relief are you requesting what relief are you requesting regarding the health insurance? You're asking for him to pay half?
Yes.
As far as unreimbursed medical, you're asking to pay half of that pursuant to the Nevada law?
Yes.
And so we've talked about the 30-30 rule. Do you recall that discussion?
Can you refresh my memory?
Absolutely. So 30-30 rule is that if you pay a bill for today, you have 30 days to give proof of it,
Uh-huh.
and he has 30 days to give you the 1/2 payment that you've made.
Okay.
And that's what you're asking the court to adopt, correct?
Yes.
Okay. What mechanism do you want to use to provide that to?
I'm not sure. What's the easiest way for the courts to track it?
Well, we talked about different options, like talking parents, our
Oh,
family
no.
wizard. You want it to go through my office, is that correct?
Yeah, I think according to his court that he went to,
Uh-huh.
they said that he can only talk to you or another attorney about the kids. So that's what the DA decided in his case. And so I'd like to do what they decided.
So you want me to send or an attorney that you direct, it could
Yeah.
be someone other than me, you want them to send medical bills and proof that you've paid it, and then him have 30 days from that proof to reimburse you.
Yes, but because they were the ones on his court date to suggest that, I believe that he should pay for that.
What do you mean he should pay for that?
Like the attorney's fees that it costs for me to send it to you and you to email it, like the time that you spend, whatever you charge me for that.
So you're asking the court that he be ordered to reimburse you for that work?
Yes.
Okay. Okay. Do you understand what it means to have legal custody?
Yes.
And what is your understanding of legal custody?
That I make the medical decisions for the kids and school decisions.
Okay. And you've asked this court to award you sole legal custody under Rivero, is that correct?
Correct.
And that's this ability to make health, education, and religious decisions for the children without notifying. Is that accurate?
Yes.
Why do you believe that that is in the best interest of the minor children?
Because it seems that every decision I make, he tries to just say no to it just to cause inconvenience. And I believe that if he's given any rights to make decisions, he'll constantly try to change them just to inconvenience me. For example, how he took him out of the kids' preschool that they were going to for 3 years for no reason. How he decides to not allow him to go to therapists for no reason. And that kind of stuff, like changing my kids' routines so often, is not good for my kids, especially my son who has such severe anxiety.
Okay. So you're asking the court to award sole legal custody, is that correct?
Yes.
And you're also asking the court that, as the sole legal custodian, that you have the ability to apply for passports for the children without consent. Is that accurate?
Yes.
You're also asking that there be a specific order that not to interfere with the children's medical treatment because it's causing trauma and unnecessary litigation fees. Is that accurate?
Yes.
Okay. As it relates to physical custody, do you agree that the children are not of an age that they can state a preference as to custody?
Yes.
Okay. There is no one other than you or that could assert rights to custody of the children, correct?
Correct.
Frequent association and continuing relationship. Besides when you withheld the children after the incident in December and January, you've complied with the court's order regarding contact for the children. Is that accurate?
Yes.
There was one time that Donna's house had to have a fee paid and they missed one visit, but we agreed to a makeup visit so that get that because you were not receiving the money to pay for child support and
Yes.
and temporary assistance or temporary support. Is that correct?
Correct.
So, and you agreed to make a visitation when he missed something at Family First. Is that correct?
Correct.
Have you tried to the best and to the extent that you can to encourage and foster the relationship between children?
Yes.
What do you do to do that?
Before visits, I just say you're going to have a lot of fun. You know, you're going to enjoy yourself. It's your dad's time to have visits, and that's about it.
When they go to Family First, does it seem to be a little bit easier for the children?
Well, yes, because every time they leave, they have an entire bag of brand new toys. So they go to the visit knowing that they get new toys. So because of that, it has been a lot easier for my son to go. He says, I want to go get my new toys, is what he says.
Who brings the new toys?
Their dad brings them.
Okay. As it relates to conflict, you have alleged in this matter that the conflict is very high. Do you agree with that?
Yes.
Do you agree that the conflict is high because of the domestic violence that's happened between you?
Yes.
Do you agree that the conflict is high because of the use of alcohol?
Yes.
Do you agree that the conflict is high because it harasses your family and friends and providers for the children, as an example, therapists?
Yes.
As it relates to the ability to cooperate, do you think that there is an ability for to cooperate with you?
No.
Have you tried to cooperate with?
Yes.
At one point, did you attempt to even interact with him one-on-one before the text messages where he said specifically that he was going to kill you?
I don't understand.
One-on-one doing exchanges and visitation, like you were doing the directly with exchanges?
Yes.
And that was before he sent you text messages saying he was going to kill you, correct?
Yes.
That's before he came to the house trying to locate you and cause damage to your house and the neighbors' houses and vehicles, is that correct? Do you feel safe currently in communicating with?
No.
As it relates to mental and physical health, do you believe that you are mentally and physically healthy?
Yes.
Are you treating with any medical providers at the current time?
No.
Do you go to therapy?
Yes.
Who do you go to therapy with?
I go to the same place that to FACT, Family and Child Treatment.
Okay. You have no problem communicate or cooperating with the with the psychological evaluation if it had been paid with Dr. Holland, correct?
Correct.
Do you believe that is physically and mentally healthy?
No.
Do you believe that behaviors in this case, as outlined for the court, demonstrate that he has issues that need to be addressed before he can be safe with the children?
Yes.
At the present time, based upon the age of the children, they're completely dependent on an adult. Is that accurate?
Yes.
And what are their current needs? Like, what are his current needs?
Well, he has severe anxiety, so he needs a lot of reassurance that he's safe. He needs a lot of reassurance that I'm going to be safe without him. He thinks that I'm going to get killed, I'm going to die if I leave him. So he needs a lot of like love and nurture, a lot of just like positive reinforcement and stuff.
How often is he going to therapy?
Once a week.
Okay. What are his physical needs?
Well, he needs exercise, of course. He needs physical activity every single day. He needs to practice his writing and reading every single day. You know, he needs to eat, so I have to feed him and stuff, make him food. He just needs to, you know, be mentally and physically stimulated every single day with activities.
Do the girls have the same level of anxiety and issues regarding you being injured as?
No.
And why do you attribute that to personally?
Because he witnessed everything, and his father was telling him stuff about hurting me.
Okay.
And I think that when he was telling him stuff, I think the girls were just kind of off in their own little world and not really paying attention.
Okay.
And so they either didn't pay attention or didn't hear it.
Okay. In your personal opinion, are the needs, the physical and emotional needs for the children different than for the girls, different than?
Yes.
Okay. What are their emotional needs then?
They're just normal, you know, they just want to play and they need, you know, they need love, but they also want their independence.
Are they currently in therapy?
No.
Okay. What about their physical needs? How are their physical needs different than?
I guess they need like less hugs and cuddles because they feel safe and secure already. Whereas like doesn't feel safe and secure, like he is always scared, so he needs like the constant like hugs and it's okay type thing.
Are you following the recommendation of the therapist regarding the amount of treatment?
Yes.
Does the therapist provide direction about what you can do to assist to move forward from the anxiety
Yes.
and the stress that he's feeling?
Yes.
Are you following those recommendations?
Yes.
What do you understand those recommendations to be right now?
Well, one of the biggest things is making him feel safe. So like constantly reassuring him that like we are safe, I am safe, and then it is my job as a mom to keep you safe, and it is my job to keep me safe, and you need to not worry about me. Just be you, be happy. Your job is to be a kid and have fun and grow and learn. So that's the biggest thing, is just reassurance that he's safe.
And that's what you're currently working, that's what the therapist is currently working on with him?
Yes, and also talking about emotions, like, you know, like realizing what he's feeling and like addressing the emotion and just accepting it.
Okay. Do you believe that you have a close and loving relationship with the kids, correct?
Yeah.
Do you believe that loves the children?
I'm not sure.
Okay. What makes you think that?
I feel like if someone loved their kids, they would do anything they could to be with them and take care of them and they wouldn't let anything stop them. No addiction, no person could stop them from being with their kids. And I mean, I would never let anything, any drug, any alcohol, anyone ever keep me from my kids. If I had a problem with drugs or alcohol and that was keeping me from my kids, I would stop it immediately.
You're bringing up drugs and alcohol. Why are you bringing that up specifically?
Because I know that that's part of his extracurricular activity.
What does that mean?
I mean, I know he does drugs and alcohol.
Okay.
And I know that's not all of the reason why he's violent, but I know that he is violent, but he gets more violent when he is on drugs and alcohol.
There was a recent criminal hearing, is that your understanding?
Yes.
And in that criminal hearing, his criminal defense attorney alleged that he has a problem with alcohol abuse. And that's my term, that's not his attorney's term, correct?
Correct.
And his attorney indicated that Scram would be a way to monitor his alcohol use and address the alcohol consumption issue. Is that a correct statement,
Yeah.
as you understand it?
Yes.
Okay. Besides your 3 kids, do you have any other children?
Not that I'm aware of.
Do you have any other children?
No.
There's no concern about abduction at the present time or attempts to abduct the kids, correct?
My son feels like he's going to come one day and take him. There was an incident where he was only seeing the kids for hours at a time, and then one day he decided to take them for 3 days, 3 nights, 4 days. And since then, my son's always been like, he's going to take me, he's not going to bring me back. Like, I wanted to call you, he wouldn't let me call you. So that kind of makes me question it a little bit, because my son's so afraid of it. And it's true, like, maybe if he does get unsupervised visits, maybe he will take them away and hide.
Let's talk about what you're specifically asking. You're asking the court for primary physical custody and for to have, if he has contact, to be supervised, correct?
Correct.
Okay. You've already gone over in detail the domestic violence.
Yes.
There was an incident previously where you guys were involved with Child Protective Services, correct?
Correct.
What happened as a result of that?
He wasn't allowed to see the kids for, I think, 3 months.
Okay.
And they made my dad for 2 weeks or a week, I think it was, they made my dad legal custodian of the kids, because they said that because I allowed my kids to see their dad knowing that he was violent, that I was negligent.
So you were failing to protect them?
I was failing to protect him by allowing him to be around my kids.
Okay.
And that's the reason why I was so adamant about when I felt my kids were in danger, like I was going to withhold them, because I was never going to let CPS take my kids away from me.
Okay. And that CPS case is now closed?
Yes.
But that happened before the filing of the divorce, correct?
Correct.
Okay. And so if the court were to grant visitation, what are you specifically asking visitation to be?
I want it really minimal right now, because my son has, like I said, severe separation anxiety, and when you give him a routine and it gets ripped away, he gets scared of abandonment. And when the dad went to jail, he kept thinking, well, he left my life. What if my mom does that too? What if my mom never comes back? And I had a month of just horrible, severe anxiety with him. Like, I couldn't go to work. He was screaming and crying. Sorry. He was getting, like, violent with my babysitter, like, throwing stuff and kicking and saying, thinking that I was never going to come back again. And so I prefer that visitation be very minimal, at least until we know for sure if he's going to be in jail or not jail, because my son needs time to heal. And he's not given that chance to heal if he constantly has to switch schools, switch visitation, see his dad, not see his dad, wonder if mom's never going to come back like dad. That's not allowing him to heal. And it's really sad seeing a 6-year-old with such severe anxiety. And it's sad when people say, like, he seems a little off, like, he seems a little different. And, like, yeah, he went through a lot. He saw stuff that he shouldn't have seen at his age, or no one at any age should see.
Let's talk about if the judge does schedule visitation, you want that scheduled between Tuesday and Thursday, is that correct?
Correct.
What happens on Mondays right now?
The girls have gymnastics.
So the girls have gymnastics and the visitation would interfere with that. Do they
Correct.
enjoy gymnastics?
They love it.
Does it give them some stability to be able to interact with kids their own age?
Yes.
And right now they're not in school, correct?
Correct.
So the only interaction they're getting with kids their own age besides is really going to gymnastics, is that accurate?
Correct.
And then what happens on Thursdays and Fridays.
Me and my son have therapy.
Okay, and you're going to that fax place.
Correct.
Okay, and so you don't want, was it difficult to schedule the fax therapy?
It was really difficult.
Okay, and why is this program so important?
Because it's a free program for people that have dealt with trauma, domestic violence, and sexual abuse, and not everybody's accepted. You have to go through an interview process, and they have to get together with like the whole group and see if they have someone that's willing to accept your case, and if they have someone that's going to be able to benefit you. Like, not everyone and not every therapist are going to mesh together well, and so we were lucky to be accepted.
Okay, and so it's best for the scheduling for the kids for it to be either Tuesdays or Wednesdays, is that accurate?
Correct.
Okay, and so if the court's gonna schedule it, that's what you're asking the court to schedule, is that accurate?
Correct.
Okay. When you say whether or not going to jail, you're talking about whether the criminal charges result in him going to prison, is that accurate?
Correct.
Right now, is it your understanding that criminal charges are set for trial in June of 2022?
Yes.
And we reviewed that at lunch, is that accurate?
Yes.
Okay. Is there any other relief as it relates to the children that you're asking the court to enter?
No.
Do you believe that before that should finalize the evaluation with Dr. Holland?
Yes.
Okay. And I know it's a weird transition, but let's transition to the property and debts, okay?
Okay.
You owned the house before marriage at Drive? I know it's weird for me. And you guys lived there together, and you don't dispute for a period of time that contributes the mortgage payment, is that correct?
Correct.
You're asking for that property to be awarded as your separate property, is that accurate? To the extent that assisted in making mortgage payments on that for a limited period of time, you're asking that any award of monies to that from the house be offset from the debts that he owes to you, is that correct?
Correct.
Besides that, you're asking to keep anything in your possession, so any computers or furniture, you're asking for those things that are in the house that you live in to be awarded as your separate property, correct?
Correct.
You're agreeing to have anything in his possession as his separate property, is that accurate?
Correct.
Are you agreeing that have the business law PC?
Yes.
Okay. And you're asking that, what are you asking the court to do as it relates to not the medical debts or the medical insurance, but the credit card debts? What are you asking the court to do as it relates to your credit card debts?
I'd like to offset some of my equity to pay, or the equity to pay up the credit cards.
And in the event that there's not, let's say the court determines that there's not enough equity to cover the debts that are already owed, what do you ask? What relief are you requesting? Are you asking to pay any of those credit card debts if it's not from the equity in the house?
Sure, yeah, that'd be good. So a lot of that stuff was for the kids.
Okay, so your testimony is that that stuff benefited the children, so
Yes.
he should be responsible for some of it.
Correct.
We've never received credit card statements from. We don't know any kind of debts like that for him. Is that accurate?
Yes.
The only credit card debt the only debt that he lists other than student loan is a Capital One credit card of $1,700, but we've never received any of those statements for Capital One. Is that accurate?
Yes.
Okay. So you're asking to pay one half of the credit card debt?
Yes.
Okay. As it relates to alimony, do you agree that he is currently not working because he is in jail?
Yes.
But for not being in jail, we would be requesting alimony in this case. Is that accurate?
Correct.
And for the entirety of your marriage, which has been how long?
Since 2014.
So you guys have been married 6+ years.
Yeah.
And so you're asking the court to set aside at least $1 a year so that in the event the law license is restored, that you would be able to come in and ask the court for a modification of alimony. Is that correct?
Correct.
As it relates to income, so at one point he was making really good money as an attorney. Is that correct?
Correct.
We understand right now he can't practice law. Do you agree with that statement?
Yes.
What did he do before he practiced law?
He worked in finance.
What did he earn working in finance?
I'm not sure, he never disclosed that to me, but he had his master's degree in finance. So I'm sure he made pretty good money. He was working in finance for Caterpillar.
And you have no knowledge of what he earned before he was an attorney.
No.
But you understand he can't practice as an attorney right now.
Yes.
So, what jobs do you think he could do reasonably when he does not have his law license?
Be a law clerk.
Okay, and what do you believe he could do? What do you believe he could earn as a law clerk?
Don't some of them make like $150,000 a year? No.
I wish.
I wish. I was just thinking me.
How much do they make?
I don't know. That's a good question. They make
Okay,
different
yeah.
amounts based upon that. Are you asking the court to use the best judgment to determine what an imputed income to Brad upon him being released from CCDC?
Yes.
Okay.
He could also work in finance.
Okay. Are you asking to be under an affirmative duty to notify you of changes of his employment and provide you his tax returns on a yearly basis through my office or through whatever attorney you
Yes.
designate?
Yes.
Okay. And you are asking the court that at the conclusion of this trial that we be able to file a memorandum of fees and costs that outline not only the costs that you've incurred with my office, but the court costs you've incurred with Joe's office. Is that correct?
Correct.
What do you estimate that you've spent in attorney fees between Joe and I? And I realize Joe is at 2 offices, but do you have any idea?
No idea. Honestly, I don't even want to look at it. It stresses me out so much.
Okay.
How much was it with you so far, do you know?
I don't know off the top of my head.
I want to say it was probably like 15,000, 20,000 with Joe Riccio.
If we filed, would you agree that the best course of action is just to file those billing statements with the court, allow the
Yes.
court to do an analysis,
Yes.
and then whatever the court deems just and equitable would be the best course of action?
Yes.
Are you asking the court for an unequal distribution of the assets and debts based upon Bad's refusal to cooperate and the orders from the court regarding his lack of cooperation when Judge Pomeroy was on the bench?
Yes.
I believe that we have no further questions, Your Honor, at this time.
Okay. All right, let's go off the record. All right, the court finds that it has both personal and subject matter jurisdiction since the children have lived here for more than 6 months prior to the filing of this action, and the parties have lived here more than 6 weeks prior to the filing of this action. That makes Nevada the home state of the children. That there is no possibility of reconciliation based upon the testimony of the plaintiff. That at the hearing held on July 30th, 2020, and the order being filed on January 24th, 2021, defendant was to pay child support in the amount of $2,560 per month and spousal support of $1,000 since the date of that per month, since the date of separation, due to his income being $18,000 per month. That defendant was still working at the firm for at least 3 months after he claimed he was no longer working at the firm. That on October 22nd, 2020, the court gave the defendant an opportunity to purge his contempt of not paying support if he immediately delivered his financial books and records regarding his business and income. This order was filed on January 20th, 2021. This was not done. Therefore, child support arrears through December 2021 is $49,377.82. You may double check my figures and the martial law calculations and provide the documentation if that is off.
Okay.
This is subject to defendant providing proof of payment of particular months in which it may not have been in the schedule of arrears that has been filed. Spousal support arrears through December 2021 is $33,982.84. Any monies that have been paid in advance will go towards any child support arrears prior to any other monies that was owed. That defendant was once again ordered to turn over his business and personal financial documents by December 1st, 2020 at the November 24th, 2020 hearing. This order was filed on December 10th, 2020. This was not done. The court's predecessor recommended an unequal distribution of the community property if this was not done. That defendant has failed to cooperate with discovery. In this, it was ordered on March 17th, 2021 that he was precluded from presenting or relying on at trial or evidentiary hearing any evidence required by Rule 16.2 not disclosed within 5 days. Any requests for admissions which were not responded to are deemed admitted by operation of Rule 36A3. These will be spelled out a little bit further down in the factors for custody. That there was an active temporary protective order in place from September 18th, 2019 until September 19th, 2020. This was case number T19T. There was another TPO that crossed over during the same time periods, and it has that case number is T20T. It has continuously been in place from September 6, 2020 until current date and will not expire until May 10th, 2022. Therefore, we have the dates of up to September 19th, 2020 on one TPO, and you had dual protection on 2 different TPOs for that period of time. That there have been multiple violations of the TPO. I forgot to put down the dates on what those violations are, but they were pretty much during the summer of 2020. Ms. Wilburn testified that she is a licensed marriage and family therapist who treated on February 2nd, 2020 and the February 24th, 2020. It stopped because defendant notified her that he did not agree with the treatment. Was under a lot of stress due to the parental conflict. He had extreme nervous problems, and he did not want his parents to be around each other. He had suffered extreme anxiety over contact with Dad. Did let Miss Wilburn know that he saw a lot of scary behaviors and saw his dad be mean to his mom and afraid of his dad getting mad. Once Miss Wilburn terminated her therapy, she referred the child to Anna Trujillo, who was not able to testify, so I am not exactly sure how long Miss Trujillo actually was a therapist to the child. That during one of the child exchanges, did not want to go and he was crying, Sarah McKinley picked him up and began swinging him around and around, and once he was able to get away, he ran to his mother, who did attempt to protect him. That there were multiple videos showing that that did not want to go with Dad. That on June 10th, 2020, the plaintiff and defendant entered into a stipulation order that there would be a full outsourced custody evaluation and psychological evaluation. This never took place. That on the order dated June 26, 2021, this court also ordered that the court shall not entertain requests to modify the defendant's visitation with the minor children until he completes the psychological evaluation. That was at a minimum. That at the time of scheduling this evidentiary hearing, the defendant made it clear his intent to put off this trial and cause even more delay. That after continuous filings that are duplicative and in many other courts regarding the same subject matters and the same parties, this court finally had to grant the vexatious litigant status against the defendant. That defendant's lack of cooperation with the outsourced evaluations, psychological evaluations, and discovery significantly increased the cost of litigation. And I apologize that these findings are going to be weaving in and out. I'm hoping that you will put these in a little bit more logical order than as I was typing them out.
Your Honor, can we correct one thing?
Yes, ma'am.
T20 was actually granted July 6th of 20, not September.
Yes, July 6th,
Okay.
2020.
I just want to correct
The
it.
other one in September was going until September 19th, 2020.
Okay.
So they overlapped each other.
Okay.
All right, let me go back and find where I was.
Sorry.
Okay, that the court recognizes the fact that the defendant has gotten into some trouble with the State Bar of Nevada and has temporarily had his license suspended, that the defendant has the ability to work as a law clerk or a paralegal, and as a seasoned, well-versed law clerk or paralegal, and believes that he should be able to earn at least $35 per hour in that arena. That the complaint for divorce was filed on March 5th, 2019, and during the almost
2020, Your Honor. I'm sorry, that's
2020, and during the almost 2-year period of time, defendant has nothing to cooperate, communicate, or compromise to act in the best interests of the children. That this needs to be moved down a little bit someplace else. Whoops. Give me a second here. I was trying to keep everything in a logical order, and it does not always work. That when it comes to the physical custody findings, on this here, the wishes of the child, the children are not of sufficient age for this factor to enter into the decision. Any nomination of guardian by the parent, there has been no nomination of guardian in this matter, therefore it is neutral. Frequent association and continuing relationship. The plaintiff has requested the defendant's visitation with children be supervised. She is requesting a schedule be set up so that defendant has an ability to maintain a relationship with the children. That mom attempted to even bribe to go with visits with his dad, but refused to go. Defendant has showed no signs of not allowing a frequent continuing relationship with plaintiff. Therefore, this factor is neutral. But it does show that mom is willing to allow the frequent associations. Level of conflict. Plaintiff was subjected to many acts of domestic violence and violations of the TPO currently in place and in the past. Defendant's communications with plaintiff, her attorneys, and the therapist for the children have increased the conflict. That at a supervised visit with Donna's house, defendant became violent with the marshals and had to be escorted out. This is from the Donna's House report filed under seal and Plaintiff's Exhibit 124 and has been admitted. We will discuss this even further, the level of conflict, when we go to the domestic violence factors. This factor weighs against the defendant and favors plaintiff. This also is a factor for consideration in the continued supervised visits for defendant. Defendant's continuous refusal to cooperate with court orders, pay child support as required, defendant's willingness to be confrontational and abusive in the presence of the children shows a blatant refusal to cooperate with plaintiff in raising these children. That defendant filed civil lawsuits against his son's therapist as well as against plaintiff and prior therapists. It shows a distinct inability of him being willing to cooperate with mom. There's also more of this when it comes to the domestic violence factors on this as well. This factor is against defendant and favors plaintiff. The mental and physical health of the parents. This factor may have been put to rest had defendant participated in the psychological evaluation that was ordered. Defendant's refusal to do so in his acts in violating the TPO raises suspicions as to a minimum his ability to deal with his anger. That at a supervised visit with Donna's house, defendant became violent with the marshals and had to be escorted out. His out-of-control behavior further shows a possibility of mental health issues that could place the children in danger should defendant have unsupervised visits with the children. There are multiple attacks and stalking of other people, He has threatened another man with a Colombian necktie, which is saying that he would slit Jason Elliman's throat, who is defendant's ex-girlfriend's ex-boyfriend. There is no evidence of such problems for plaintiff. This factor is against defendant and favors plaintiff. Defendant has posted many false reports regarding many professionals involved in his family's life, from therapists to the attorneys to the judges. He posts rants that are hard to follow and to understand, and there's further factors that is going to be listed in the domestic violence factors. This factor, once again, is against defendant and favors plaintiff. And while I'm thinking about it, Mom, if you want to go on back and sit with your attorney, you may do so. I forgot you were still sitting there. The physical, developmental, and emotional needs of the children. The children are young, but one of the children has shown the need for therapy regarding his being subjected to domestic violence and adverse treatment of his mother, not once, but twice. And adverse treatment of his mother. He's been denied this therapy not once, but twice, with Anna Trujillo and Donna Wilburn. Was to continue in therapy by orders of this court, yet defendant filed a civil lawsuit against his therapist. This child has threatened physical violence against adults and has threatened to kill his mother. He is just 6 years old. This factor is against the defendant and favors the plaintiff. Since it is possible that is learning this behavior from defendant, his showing of anger, this factor also must be considered when determining supervised visits for defendant. The nature of relationship with the parents. Children do have a loving relationship with plaintiff. There's been no evidence put into the record that shows otherwise. With it being more than a year since defendant has had anything more than supervised visitation, the relationship between the defendant and the children will probably need to be rebuilt once he finishes a psychological evaluation as was previously ordered and once his criminal problems are straightened out. This factor favors plaintiff and is against defendant. There are no other known siblings other than the three involved in this case, therefore this factor is not applicable. When it comes to the abuse and neglect, defendant has thrown food and juice boxes at the children when they ignored him during a child exchange. This could be deemed abusive. That abusing the mother in front of the children is abuse of the children as well. It does cause psychological harm, and the court cannot tolerate any further harm coming to these children. This factor is against defendant and favors mother. As for abduction, this factor is not applicable since there has been no abductions in this case. Domestic violence. There's been testimony, and the court does find that during the mom's first pregnancy is when the violence began and continued onward. That the ones with the most evidence began on August 6, 2019, when defendant left bruises on plaintiff's arm and thigh by banging the door on her with watching. Defendant tore the garage door off and then he left. That on September 16, 2019, defendant began banging on the front door, then broke a back window, getting into the home and began throwing furniture around, including the TV from the master bedroom that was thrown from the second floor to the floor below. Was once again present for these events. Police were on the phone while defendant was still destroying the property. He destroyed the children's fish tank, causing the fish to die in front of the children. The dishwasher was kicked in. That defendant ripped the fan above the stove out of the wall. The garage was destroyed. He ripped the TV off the wall in the living room. He broke multiple mirrors, artwork, and bottles of wine, as well as the children's fish tank. He ripped doors from the hinges in the bathroom cabinets. He threw pictures into the toddler's bed that the toddler could have very easily have been in. He kicked the toddler gate from the wall. Water from the fish tank destroyed the cabinets in the sink. Exhibit 31 is a detailed invoice for the damage caused from this night. That on June 22nd, 2020, that defendant backed his car into the garage, in the marital home's garage, after threatening to kill the plaintiff. When he figured out that she was not home, he began backing his truck into neighbors' vehicles. He drove forward and backed up into a city light pole, knocking it down onto another neighbor's vehicle. He had come back up and down, hitting other vehicles, possibly with his car, but actually with sticks. He would also drive up and down the road and hitting plaintiffs and pulling into the plaintiff's driveway and hitting the garage door multiple times with his truck. Defendant then showed up at plaintiff's dad's home, the maternal grandfather, and plaintiff barricaded herself in the bathroom with all the kids. Her dad had a shotgun to protect his daughter. The police arrived and arrested the defendant because he was violating the TPO that was currently in place, T19T. This at the same time was a criminal act all on its own and not just a violation of the TPO. That sometime in February 2nd, or that on February 2nd, 2021, the defendant once again showed up at plaintiff's home to return the children, and he began throwing food at plaintiff's front door with the children present at the door, and the the juice boxes could have very easily have hit the children. He did this because it appeared that the children did not respond to his calling them. At this visitation, he returned the children late by 33 minutes. And this was during a short time period in which he had unsupervised visits. There are criminal charges pending against the defendant, and he is still in custody. That the plaintiff propounded requests for admissions that were deemed admitted due to the defendant's not responding. That these admissions were that he committed acts of domestic violence against plaintiff as defined by NRS 33.018. That he entered a plea to battery in case number 19F 19371X. That under that same case number, he was required to complete impulse control courses. That he was required to complete domestic violence counseling, which obviously failed to take effect considering how he's reacted after that. That on or about August 1st, 2019, he struck on the left side of her cheek. That on August 1st, 2019, that he caused a welt on the left arm. That the bruises depicted in photographs attached at Exhibit 1, and that we also had as exhibits in the record here, were caused by the defendant on August 1st, 2019. That he had threatened to place Gabe in the ground. That he stated that he was going to murder someone known to. He stated that Mario would be drinking through a straw till he dies. He stated that he was going to destroy the fucker's life. He threatened to kill anyone who was in a relationship with the plaintiff. He threatened to kill the plaintiff herself. That he caused the marital residence to be in the condition depicted in the photographs that is currently on record and in the at Exhibit 2 of the request for admissions. That he caused physical damage to the following personal property items in the plaintiff's residence: 2 televisions, 2 chairs, appliances, furniture, broken vase, and a fish bowl, which actually killed the poor fish. that he caused physical damage to the home where resides at the rear window, front door of the residence, and lighting fixtures. That he caused bruises on the plaintiff on or about September 16, 2019. That he caused redness to be left on plaintiff's left shoulder. That he caused redness to be left on her left elbow. That he caused redness to be left on the left side of her back. And that one of the minor children witnessed him committing these acts of violence, of domestic violence as defined by NRS 33.018. That mom has received multiple text messages from defendant that is threatening her with killing her boyfriend and showing that he is stalking plaintiff and her boyfriend at the time. This took place in September 2019. That defendant was threatening plaintiff's dad. That he threatened plaintiff's college friend. That he has threatened every person that has had a personal relationship with plaintiff in an attempt to, I can't think of the word. Alienate her from all people that she had a close relationship to. He would harass all the professionals in such a way as to attempt to get these people to drop the plaintiff as their clients or therapists or whatever professional relationship that there was. That defendant has a habit of not following the supervised court orders. On November 14, 2020, Sarah McKinley was supposed to be present for supervised visits. She was not. That both the paternal grandfather and the maternal grandfather were supposed to be present for this visit. They were not. That on November 21st, 2020, was supposedly being under supervised visits. But on the video, it showed that defendant is all alone at defendant's parking garage with the children. No supervisor was present. Sarah McKinley was supposed to be the supervisor on that. That the residence located was purchased prior to the parties' marriage. The mortgage payment since the marriage has been made from community funds up to and including December 2021. This would have been 88 payments at $1,011. I'm going to make it that consistent payment. This would have equated to $96,800 of community funds to be paid. However, once COVID hit, $14,197.34 of these payments are being deferred until the end of the mortgage. Therefore, the mortgage payments, that figure is off. It would be $997, I believe what it is. Because I forgot to go in there and change the amount up there. One half of the total payments that was made, though, I believe, is $60,573.32. I've had to redo these figures a couple of different times, so we may need to double check my math. One half of this is $30,286.66. From this, defendant's child support arrears should be subtracted from that. His child support arrears is $49,377.82. Therefore, there should still be child support arrears of approximately $19,091.16. There's spousal support arrears, which will be discussed below. There's cost of repair to the property due to defendant's wrongful acts of $21,425.35. The defendant needs to reimburse 100% of those costs. That there are outstanding medical costs totaling $3,453.23. One half of this amount is $1,717.61, which will be the defendant's responsibility to reimburse the plaintiff. This is Las Vegas. People are going to gamble in this town. When things stress them, they go to the casinos. It comes with the nature of the beast that Las Vegas is. The court is not going to find that there was community waste when it comes to the gambling. However, defendants destroying his law practice, stealing funds from clients, and losing his license to practice law is community waste. And I can't say that the money that he spent in the casino was not his client's funds that he stole. I'm not sure where that money come from. So I cannot say it was necessarily community waste, but he has destroyed what could have been a lucrative community and has destroyed it down to nothing. But without further documentations, we have no way of showing what it is. Whatever cost that was associated for his law practice is going to become his sole and separate debt, whether it's the PPP payment or whatever wrongs that people come and sue him for will be his sole and separate responsibility. That the court does find that plaintiff's Bank of America account ending in 6343 at $1,120.62. The Bank of America account ending in 0153 in the amount of $2,712.58. That the Chase credit card ending in 5682 and was later changed to 5254 in the amount of $1,044.89. The Chase account ending in 5919 and later changed to 7774 in the amount of $6,200 are all community debts and should be equally divided. The student loans in which Mr. produced the records on were all obtained prior to the marriage and therefore is his sole and separate debt. Any other debt that's not listed above shall be each person's sole and separate debt. That the request for contempt findings, the plaintiff has decided not to pursue any of the rest of the contempt proceedings from this case. Attorney's fees findings, that an award of $3,239.50 was awarded to plaintiff on April 21st, 2021. That plaintiff was already awarded fees in the amount of $2,659.50 on the order in September 20th, 2021. I believe both of these were from the Discovery Commissioner. Therefore, the court hereby orders some of the stuff that was above that I went ahead and added as an order up there. But the bonds of matrimony, now and heretofore existing between the parties, are hereby wholly dissolved, set aside, and forever held for naught, and an absolute decree of divorce is hereby granted to the plaintiff, and each of the parties are hereby restored to the status of single, unmarried persons.
I have a question, Your Honor.
Yes, ma'am.
To the spousal support debt, I got the child support, and maybe I was running the numbers and maybe I missed it. I don't see we reduced that to judgment.
I haven't got there yet.
Oh, okay.
That amount
Sorry.
is going to be reduced to judgment.
Okay.
Just in case I forget to say so. Let me go back down where I was. I just had to let her get her excitement out of the way.
I'm so happy.
That the plaintiff is awarded sole legal custody of the parties' minor children. Date of birth 01/15/2015. date of birth 11/20/2016, and date of birth February 1st, 2018. It may be determined to be a change of circumstances if defendant submits to the psychological examination as was previously ordered, except at his costs from this point forward. This sole legal custody will include the right to obtain passports and travel out of the country without defendant's permission. The plaintiff is awarded primary physical custody of the party's minor children, subject to defendant's right to weekly 4 hours of supervised visits at Family First at defendant's cost after the father has petitioned the court and after his criminal problems have been cleared up, so as not to add any more problems to psychological health. This supervision must be closely supervised for the ability to overhear all conversations between defendant and the minor children. If there is any inappropriate comments or actions, the visitation must be cut off immediately. The next scheduled visit may take place as scheduled. It may be determined changed circumstances if defendant submits to the psychological examination as previously ordered, except at his cost from this point forward. That defendant's child support is temporarily suspended due to his current incarceration. This will begin January 1st, 2022. Upon his release, his income will be imputed at the amount of a seasoned law clerk of $35 per hour until defendant obtains gainful employment and submits a financial disclosure form. At $35 per hour, this equates to $6,067 per month. With 3 children, defendant's child support obligation upon release from incarceration will be $1,569 per month beginning the month following his release. That after all the proper math is done, the child support arrears will be reduced to judgment. He will be given an opportunity to see if he can show any other payments that he made, that it will not be on the affidavit of the schedule of arrears. I will afford him the opportunity to show that, since he was not here today to do so. That plaintiff is to provide health insurance for the party's minor children. Defendant is to reimburse plaintiff for 1/2 of these costs. These costs may fluctuate as time goes by, so the plaintiff will need to keep him up to date on what these health insurance costs are. That the parties shall equally share the cost of the children's unreimbursed medical expenses utilizing the 30-30 rule. That the plaintiff is to receive the child tax credits each year. Spousal support arrears through December 2021 is $33,982.84. This amount is reduced to judgment. Going forward, spousal support is set at $1 a month until defendant is no longer incarcerated. Then defendant's spousal support obligation shall be set at $500 per month, modifiable based on defendant's earning abilities. The defendant shall provide his tax returns to plaintiff every year until the last child reaches the age of majority. That 1/2 of those, PPP. What am I forgetting here?
The duration of the alimony you're on?
The duration of the alimony is going to be 7 years.
Okay.
And that's primarily because I'm pretty sure he's going to do everything he can not to pay it. So I'm going to make him go the full 7. Okay, attorney's fees. that the plaintiff is awarded attorney's fees and costs and is to provide a memorandum of fees and costs and the Brunzell factors. These attorney's fees are going to be from not only Ms. Roberts' law firm, but plaintiff's prior counsel as well. This is to be done within 30 days. I am allowing a longer period of time to do the memorandum of fees and costs due to the holidays, and Mr. may get out of jail, so I'm going to give him a little bit of leeway so that he's got a little bit longer time to be able to come in and put in an objection on this. But I will not wait for more than the normal 14 days past that 30 days. So Mr. will have 44 days from today to be able to file an objection. That plaintiff's former or maiden name of is restored, if she so desires, after she realizes her last name will not match the children's last name. I believe I've covered
I think we missed the medical expenses, Your Honor, the 1761.
that. Those are reduced to judgment as well.
And then can we just run over the math so I can make sure my
Please.
findings?
Yes, let's make sure that the findings are correct on the math while we're sitting here, because I've noticed my numbers bounced and I had one amount that should have been changed a while back and it didn't work out.
Okay, so I have 88 months at 1011, which means it's 88,968.
Correct, 88,968.
Then I have 14,179
Hold on.
as the deficiency amount that's added to the remainder of the loan. So I come up with 74,798. Is that where you're at so far?
70, yes, that's where I'm at. 74 what?
74,789.
Yeah,
Or wait, 74,789.
okay.
And then I divide that in half, and it would be 37,394.50. We're gonna first apply child support to that
Correct.
of 49,377.82, which means his child support arrears are not 19,000; they're 11,988.32.
Correct, that's right, thank you.
I just want to make sure that I had it right.
Yes, well, and I knew I was going to have to go back in, redo the math on that, because I had noticed my beginning figures did not change, so it just threw everything off.
2 questions.
Yes,
the
ma'am.
psychological evaluation, that would be conducted by Dr. Holland. Is that accurate?
That shall be conducted by Dr. Holland
Okay.
or someone at plaintiff's choice if Dr. Holland is not practicing at the time.
Plaintiff's choice,
Plaintiff's choice.
if Dr. Holland is not practicing. Just so I'm clear for the visitation, it's essentially suspended until the criminal issues are resolved, and then then all the terms closely monitored,
Correct.
overhearing. Okay. Half of the insurance that she's paid to date, is she going to get reimbursed that amount as well, Your Honor? That amount was, she testified that amount was,
267.66 times 2
3 times 3.
times 3.
so I have that amount as $12,191.04 would be his half.
Correct.
Okay.
And you said you wanted,
Can we make, is it possible, and if not, I can appreciate that, but I think we've already done it. The T19 case, I believe that the court's finding is that was never dismissed, and so it remained active, and I just want to make sure that's clear.
correct, it was not dismissed, therefore it remained active until September of 2020, So at one point, you had dual TPOs that overlapped.
Okay. I believe that covers everything. We appreciate the court's time.
All right? Thank you.
Thank you.
I hope you'll prepare the order and get it by the end of the year so that she can start the new year out right.
I will, Your Honor. I
Thank
appreciate
you
it
so much. We appreciate your time.
And then
Are you
because
gonna
it's
be-
voting, by the time I get back, it'll be 4 o'clock. Can I do that under seal tomorrow, Your Honor?
Yes, ma'am.
If I don't know if that I'll be able to draft it before 5 and get it filed.
You don't have an extra card that you can take your box.
We have enough room, I think, that we can take them, yes.